Welcome to the Deep Dive, brought to you by MyChesCo. I'm Chris.
And I'm Michelle.
And today, Michelle, we are unpacking some truly significant news.
Yeah.
News that's really going to send ripples right through our Chester County community.
That's right, Chris. Today we're diving deep into a very recent Supreme Court ruling. It's Mahmoud et al. V. Taylor et al.
Okay.
Docket number 24-297, decided just, days ago, on June 27, 2025. It's a landmark case.
Right.
And, while it started over in Montgomery County, Maryland, the implications are, frankly, massive for everyone here in Chester County, especially if you're a parent or a student or maybe someone involved with our local school boards.
Okay, Michelle, so let's really unpack this. We're talking about how this ruling could directly maybe reshape curriculum decisions right here in our schools.
Exactly. And what it means for parental rights.
Parental rights, yeah.
And also how our local schools, will need to navigate and balance all those diverse community values right here.
In our own neighborhoods. So for anyone with kids in school or really just an interest in what shapes our community, this is a deep dive you won't want to miss.
Absolutely.
And hey, if you find this valuable, please make sure to like, share, and subscribe. It really helps us bring more of these vital discussions to you.
It really does, Chris. And like you said, this isn't just some distant legal thing. It's about what happens potentially in your child's classroom.
Or what might need to change in our local districts.
Precisely.
So let's set the stage then, Michelle. Where did this whole controversy even begin? What was the spark in Montgomery County, Maryland?
Well, Montgomery County is Maryland's most populous county. And interestingly, it's been identified as maybe the most religiously diverse county in the whole nation.
Wow.
Yeah, it's got this huge mix of Christian denominations, but also ranks incredibly high for Jewish, Muslim, Hindu, and Buddhist populations per capita. Just a real melting pot.
Okay.
And it's home to Montgomery County Public Schools, MCPS, one of the largest districts in the country, over 160,000 students. It's huge.
So that diversity, it's really crucial context for understanding how this all started.
And it sounds like this diversity wasn't just like background noise. It directly played into the curriculum decision.
Oh, absolutely. In the 2022-2023 school year, MCPS decided to introduce these, what they called LGBTQ plus inclusive storybooks into their K-5 curriculum. So kids aged about 5 to 11.
Right, the younger grades.
Yes. And the board said their existing English language arts curriculum wasn't, quote, representative enough of the county's diverse students and families.
Okay, so representation was the goal?
That was part of it. But their stated goal, quite explicitly, was also to, and these are their words, disrupt children's thinking about sexuality and gender.
Disrupt. That's a strong word for elementary kids.
It is. They explicitly aimed to disrupt heteronormativity and cisnormativity. Basically, challenging the idea that being straight or identifying with the gender assigned at birth are the only norms. Disrupting those sort of fundamental concepts in elementary school. I mean, that sounds like a pretty bold directive. What kind of books are we talking about here?
Yeah, well, some specific examples really show the intent. There was one called Intersection Allies. It features a transgender child named Kate, talks about safe space bathrooms. And its guide for teachers actually stated, when we are born, our gender is often decided for us based on our sex. But at any point in our lives, we can choose to identify with one gender, multiple genders, or neither gender.
Wow. So quite direct.
Very. It even prompted kids with, what pronouns fit you best?
Okay. And there were others.
Yes. Prince and Knight. That's one where a prince falls for a knight. They have a same-sex wedding. Then Born Ready. The true story of a boy named Penelope.
Okay.
That's about a biological female who insists, I am a boy. And in the book, the mother says, not everything needs to make sense. This is about love when someone questions it.
Sort of framing transition as positive and questioning it as harmful.
That's how the court interpreted the message, yes. And Uncle Bobby's Wedding was another one people talked about a lot.
Wow, I remember hearing about that one.
Yeah, it's about a little girl, Chloe, whose favorite uncle, Bobby, marries his boyfriend, Jamie. It's presented as, a very joyous event.
Okay.
And the mother explains, when grown-up people love each other that much, sometimes they get married. The Supreme Court noted it sort of subtly conveys that marriage is about love, regardless of sex, and acceptance should be celebrated.
So these books, they were pretty direct in their messaging, not subtle at all, really. And teachers were told to use them in a specific way, like No flexibility.
Zero flexibility, it seems. Teachers were expected to use them in instruction, and they were explicitly told not to let students opt out.
No opt-outs at all.
None. And the board gave guidance for discussions. For instance, if a kid said 2 men can't get married, the teacher should say 2 men who love each other can decide they want to get married. Or if a child said he can't be a boy if he was born a girl, teachers were told to respond, that comment is hurtful. The guidance also pushed teachers to disrupt the either thinking of students.
Yeah. I can only imagine the reaction from parents, especially given that religious diversity you mentioned. Sounds like a real collision course.
You're absolutely right. Parents from very diverse religious backgrounds, Muslim, Catholic, Ukrainian Orthodox families, they strongly objected.
Yeah.
They felt these books and how they were being taught directly conflicted with their sincere beliefs about sex, gender, marriage.
Yeah.
And initially, MCTS had actually allowed opt-outs. They had these guidelines for respecting religious diversity, committed to reasonable accommodations, so parents felt okay at first.
But, that didn't last, did it? What changed?
No, it didn't. In March 2023, MCPS pulled the plug on the opt-out policy.
Just like that. Why?
They claimed that handling the, quote, growing number of opt-out requests was causing significant disruptions in the classroom.
Disruptions.
And they also raised concerns about potential social stigma and isolation for LGBTQ plus students if others were opting out.
Okay, I can see that being a concern. But for the parents?
For the parents, this decision left them feeling, as they put it, religiously compelled to pull their kids out to private school, homeschool.
Which costs money, time.
A huge sacrifice for many. It basically put them in an impossible spot. Either compromise deeply held beliefs or leave the public system they pay taxes for.
And that's the point where they felt they had no choice but to, well, sue.
Precisely.
Yeah.
The parents filed a lawsuit. They argued this no opt-out policy violated their First Amendment right to the free exercise of religion.
Okay.
And they drew a direct line to that big Supreme Court case, Wisconsin v. Yoder.
Right, the Amish case.
Yeah.
Where parents could pull kids after 8th grade for religious reasons.
Exactly. The parents here argued Montgomery County was forcing a similar impossible choice. But both the local district court and then the Fourth Circuit Court of Appeals sided with the school board initially.
Ah, okay. So the lower court said no, the school board is okay here.
Yes, which set the stage for the big appeal to the Supreme Court.
And this is where it gets really, really interesting. And like you said, potentially groundbreaking. The Supreme Court's decision, Justice Alito writing it, just flipped those lower court rulings completely. A 6-3 vote. Michelle, what's the absolute core of that majority argument? What makes this ruling so, well, potent?
Yeah, the core takeaway, Chris, and what makes this so significant is how the Supreme Court recognized that even sort of indirect pressure on religious beliefs in public schools can be a problem, not just direct orders.
Okay, indirect pressure. How do they define that?
Well, the majority, led by Alito, said the parents deserved a preliminary injunction, meaning the board must notify parents and allow opt-outs for these books and similar ones.
Must allow opt-outs.
Yes. Alito really emphasized the long-recognized rights of parents to direct the religious upbringing of their children. He pointed straight back to Yoder and argued that government policies that substantially interfere with kids' religious development, posing a very real threat of undermining those beliefs, well, that constitutes an objective danger to free exercise.
A threat of undermining. That sounds broader than just forcing someone to do something.
It is. It significantly broadens the potential scope of Yoder, many observers would say.
So the court didn't just see these books as like mere exposure to different ideas.
Yeah.
They saw them as an actual threat.
Exactly. That's a crucial distinction they made. The majority found the books unmistakably normative, meaning they weren't just neutral information.
Right. They were pushing a specific viewpoint.
Yes. Pushing certain values, acceptance of same-sex marriage, gender fluidity as things to be celebrated, and importantly, framing contrary views as hurtful. That, plus the active teacher reinforcement, they said, created psychological pressure to conform on these young, impressionable kids. They explicitly said this goes far beyond mere exposure.
Okay. And what about the school board's arguments? Like saying this is just their internal affairs or that the Yoder case was totally unique?
Alito shot those down, too. He said running public schools isn't like the government just administering broad policies like Social Security or managing federal lands, distinguishing it from cases like Bowen v. Roy or Ling.
So schools are different.
Yes. And he specifically said Yoder is not sui generis. It's not some unique one-off case. Its core principle, that government actions can undermine religious beliefs. That applies more broadly.
Okay.
The court also said parents don't have to wait for, actual proven damage or rely only on what their young kids tell them. The board's clear intent, the way the program was set up, that was enough to show the burden.
So the burden on religion was clear to the majority, which meant they had to apply a really high legal standard.
Right. Because they saw the burden as being of the same character as that in Yoder, they applied strict scrutiny.
And strict scrutiny, that's a tough test for the government to pass.
It's a huge hurdle. The government needs a compelling interest, a really, really important reason. And the policy must be narrowly tailored, the least restrictive way to achieve it.
Okay. So what was the board's compelling interest? Did it pass?
The board claimed a compelling interest in basically an undisrupted school environment, but the court said, well, that argument is undermined.
How so?
Because MCPS already allows opt-outs for other things, like family life and human sexuality classes, or for kids needing language support or special education students.
So if they could manage opt-outs there.
Exactly. If they could manage those, why not these books? The court basically said the board's concerns about unsustainably high numbers of absent students were, quote, self-inflicted.
Self-inflicted? How?
By choosing to create such a pervasive curriculum in the first place, weaving it throughout everything, instead of keeping it maybe in discrete units where opt-outs are easier.
Fascinating. So Alito and the majority really leaned hard into parental rights, saying the school board didn't meet that super high bar. Now, Justice Thomas wrote a concurring opinion. What did he add?
Right. Thomas agreed with the majority, but added a couple of key points to really hammer it home. First, he talked about the historical recency of this kind of education.
Meaning it's new.
Yeah. He argued that teaching young kids about sex and gender identity is a relatively recent development. It's not like reading, writing, arithmetic, not historically seen as critical for civic development in the same way.
Okay.
He compared it to Yoder, where the court looked at compulsory education beyond 8th grade, saying there wasn't a long tradition supporting that either. So no long tradition of this kind of instruction or of preventing opt-outs for it.
Interesting point. If it's new, maybe it gets looked at more closely in this kind of conflict. What else?
Second, Thomas felt the board's policy was really seeking ideological conformity.
Conformity.
Right. He actually drew a parallel to a very old case, Pierce v. Society of Sisters from 1925. That's the case that famously said the child is not a mere creature of the state. The state can't just dictate everything a child learns or believes.
Right. Parents have rights too.
Exactly. And Thomas pointed to statements reportedly made by board members, things about parents parroting dogma or comparing concerned parents to white supremacists or xenophobes.
Woo.
He saw that as evidence of an attempt to essentially standardize how students think about these issues. And he also echoed the self-inflicted disruption point the board made opt-outs hard by weaving this stuff everywhere.
Okay, so we have a strong majority, reinforced by Thomas. But it wasn't unanimous. There was a dissent, Justice Sotomayor, joined by Kagan and Jackson. A very different take, I assume.
Very different. Justice Sotomayor argued forcefully that mere exposure to objectionable ideas just isn't a violation of the Free Exercise Clause.
Mere exposure. Back to that idea.
Yes. She argued public schools are meant to promote a common destiny, a multicultural society. Kids will encounter diverse viewpoints there. That's part of the point.
Okay.
She distinguished this situation from cases like Barnett, where kids were literally forced to salute the flag against their religion, or other cases where there was clear coercion. She suggested, seeing a teacher's same-sex wedding photo wouldn't be a violation. Incidental exposure is just part of public life.
So for her, the majority's whole threat of undermining test, that was the big problem.
A huge problem. She called that test novel and basically said it was squarely foreclosed by precedent. She pointed back to Ling and Bowen, interpreting them to mean government actions affecting spiritual development aren't really actionable unless there's direct compulsion.
Okay.
She found it frankly remarkable that the majority could equate a book like Uncle Bobby's Wedding with the kind of existential threat the Amish faced in Yoder. She worried the test lacks any meaningful limit.
Meaning it could be applied to almost anything.
That was her fear. Could it apply to teaching patriotism, women's rights, evolution? What about just a teacher casually mentioning their family? She worried it could lead schools to just censor everything to avoid lawsuits.
So her concern wasn't just the books themselves, but the kind of the ripple effect, the impact on how schools function day to day.
Precisely. She warned about potential chaos for public education. imagining impossible administrative burdens for schools trying to track potentially hundreds of different religious objections, manage individualized opt-outs, create special exams, supervise kids who are opted out.
Yeah, that sounds complicated.
She foresaw chilling effects, where schools might just self-censor sensitive topics, especially potentially impacting representation for LGBTQ plus students, just to avoid the headache and legal risk.
And what about local control? Who gets to decide what's taught?
That was another big point for her. Sotomayor argued this ruling wrongly shifts power away from democratically elected school boards and gives it to individual parents and ultimately judges.
Undermining the local democratic process.
That was her argument. She pointed out that in Maryland, the democratic process was actually working. There were appeals processes, local elections where some board members who supported the policy were voted out, some books were even removed. She felt the court should have let that local process play out.
Wow. Okay, so clearly a very complex ruling. Strong arguments, fundamental disagreements about public schools, parental rights. So, Michelle, let's bring it home. What does this all mean for you, our listeners, right here in Chester County? How does Mahmoud v. Taylor connect to our local community, our schools, our families?
Yeah, this ruling has very direct implications for Chester County school boards. They'll almost certainly need to look closely at how they handle curriculum development, especially around sensitive topics like gender and sexuality.
So reviewing policies on notifying parents, on opt-outs.
Absolutely. They'll need to reevaluate those policies. And it's interesting, Chris, because Pennsylvania already has a state regulation, 22 Penn Code Section 4.4.
Okay, what does that do?
It actually permits pretty broad opt-outs from, quote, discrete aspects of the public school curriculum based on religious beliefs.
Ah, so we already have something like this in PA law.
We do. So this Supreme Court decision really reinforces that existing framework. It gives it teeth, you could say. It sets a clear federal precedent that our local schools might already be somewhat familiar with, or will now certainly need to adapt to more rigorously.
And for parents listening in Chester County, this strengthens their hand, doesn't it?
It absolutely does. For you as a parent, this ruling really reinforces your right to seek accommodations if specific curriculum materials conflict with your sincere religious beliefs.
Meaning schools might be compelled to give notice, offer opt-outs.
Yes. For content that's deemed to substantially interfere with your child's religious upbringing, schools may now be compelled to provide advance notice and clear opt-out options. It empowers parents, really, to be more active partners in their child's education on these specific topics.
So this could mean changes. Changes in what's taught, how it's taught, definitely the administrative side of managing opt-outs. Sounds like our Chester County school boards have a real balancing act ahead.
They really do. You have to consider, how does this influence classroom discussions? Where do the resources come from to manage potentially more opt-outs? And how do you maintain an environment that feels inclusive and welcoming for all students? It raises that big question for all of us here. How will our local schools balance the need for a comprehensive curriculum, one that reflects diverse perspectives and ensures a welcoming space for every child, with this newly solidified parental right to direct religious upbringing?
It's a delicate balance, like you said.
Yeah.
And it's going to require thoughtful engagement from everyone in the community, won't it?
Absolutely. It's a conversation that needs to happen locally.
Well, that is definitely a lot to think about. It's a conversation, as you said, that's really just beginning here in Chester County. Thank you, Michelle, for walking us through this incredibly important deep dive.
My pleasure, Chris. It's vital our community understands these big shifts.
And to you, our listener, thank you for tuning in to MyChesCo Deep Dive. We want to give a special shout out today to Michael in Westchester. Thanks for listening, Michael.
Yeah, thanks, Michael.
If you found this discussion valuable, please do us a favor. Like, share, and subscribe. It really helps get the word out. Remember, new deep dives land every Monday, so you can always stay informed with us.
And we really want to hear from you on this one. What stands out to you from this ruling? How do you think this might impact your family, your school, your community right here in Chester County?
Definitely. Leave your comments below the episode. And as always, for more comprehensive coverage of everything Chester County news, information, events, including more details on this topic, head over to mychesco.com.
Thanks for listening, everyone.
We'll see you next time.